Mr. Deering. He's checking in right now or logging in right now. Sophia Nelson.
All right, I have you checked in also.
Good morning, Madam
Jeff?
Clerk.
Okay, go ahead.
Good morning.
Sorry.
I had emailed in, myself and Brendan Sawyer from the prosecutor's office are going to zoom in on a matter that's up on Wednesday. My client's scheduled for exams, but his father passed away, so we're asking to adjourn.
All right, I have to pull the file in a minute.
Absolutely. Thank you.
Thank you. Anyone else need to check in?
Left a message in the meeting chat. I'm not sure if
Mr. Williams, are you ready? Attorney Williams?
Yes, ma'am.
Okay.
Yeah.
Oh, well, I'm ready whenever you are, Judge. Are you still on?
Yeah.
You said give him a minute.
Okay. I need
Oh, you need dockets, all right.
time for next week.
There was something I was missing.
You just sign this?
Yeah, they're, discovery orders. Oh, no, I'm sorry, Judge. You want me to finish? Discovery orders. You can look at.
Oh,
Sorry.
The 36th District Court, City of Detroit, State of Michigan, is now in session with the Honorable Patricia, Ronald Giles presiding.
Parties ready on Nathaniel Barnett.
Yes, ready.
Calling case number 2356198, the people of the state of Michigan versus Nathaniel Barnett Jr. Defendant number 1 is charged with count 1. Controlled substance, delivering, manufacturing cocaine, heroin, or another narcotic less than 50 grams. Count 2, weapons, felony, firearm. Count 3, controlled substance, delivering, manufacturing cocaine, heroin, or another narcotic less than 50 grams. Count 4, weapons, felony, firearm. Count 5, controlled substance, delivering, manufacturing cocaine, heroin, or another narcotic less than 50 grams. Count 6, weapons, felony, firearm. Count 7, controlled substance, delivering, manufacturing. Count 8, weapons, felony, firearm. Count 9, controlled substance, delivering, manufacturing. Count 10, weapons, felony, firearm. Count 11, controlled substance, possession, cocaine, heroin, or another narcotic less than 25 grams. Count 12, weapons, felony, firearm, habitual, strike the habitual offender. This matter is scheduled for probable cause conference.
Good morning, Judge Alfredo, on behalf of the people, P number P86590.
And good morning, Judge. Daniel Williams for the defense, P72085.
Is Mr. Barnett on?
No, Judge. I spoke to the clerk this morning. My office was just retained. We filed an appearance late yesterday. We're going to be seeking to waive his presence for today. I have good contact with the client. He's aware of the charges was arraigned. He's out on bond. I'm looking to see if the court would be willing to put this over for a week, as I am currently out of town and would like to get back to you the discovery before we hold the PCC, Judge.
Well, I will adjourn. No, not adjourn it. I will excuse your client's appearance for the purpose of this hearing. I'll adjourn PCC. They'll set it for exam.
That's fine, Judge. The exam is set currently for the 17th. I won't be back in town and available until the 19th. Would the court be willing to set the exam date on the 19th?
Hold on. April 19th at 9 o'clock?
Could we do 9:30?
No. I have one at 9:30.
How about the 20th, Judge? Does that work for the court?
I'm not putting it off that far, 9:45?
9:45 on the 19th or the 20th?
Yeah. On the 19th.
9:45 should work.
That's 9:30.
Yeah, 9:45 should be fine, Judge.
All right. All right, anything else?
No, Judge, just verify that's going to be in person.
Yes. It'll be in person.
Good. See you then.
All right, thank you.
Thank you, Your Honor. You and your staff have a great day.
You too.
Attorney Nelson, is your client on, or are you waiving your client's appearance?
We can waive his appearance. He was on. I saw his phone number and there was a lot of background noise from it. So I don't know what happened. Let me check with him.
That, I don't think.
It was that 6613 number, the 313-6613. It's gone now, but
Oh, okay. So you're waiving his appearance?
I'd like to get him on. I'm sorry.
Okay, all right, that's all I got, Judge. The other two, I gotta pull the files.
Right.
And,
Oh, he's here. He's here. Jaylene Deering.
How you doing? Hello?
Wait.
Can you hear me?
yes, hold on. Calling case number 2260648, the people of the state of Michigan versus J. Lee Deering. Defendant is charged with count 1, uttering and publishing. This matter is scheduled for a probable cause conference.
Good morning, Your Honor. Remand Proof MCAS, the people, P828800.
Good morning, Your Honor. Sophia Nelson of Neighborhood Defender Service on behalf of Mr. Deering, P77960. Mr. Deering is present via Zoom. Mr. Deering, please state your name for the record.
J. Lee Deering.
Judge, at this time, the people move to dismiss this case against Mr. Deering for insufficient evidence.
Your Honor, in my conversations with the prosecutor's office about this case,
Ms. Nelson, I just need to know if you have any objections to that. They're moving to dismiss.
right, I want to clarify that it's with prejudice.
With prejudice.
How can you dismiss something with prejudice? As in, I can't dismiss something with prejudice that I have not heard. I'll dismiss it without prejudice. I have no authority to dismiss with prejudice.
The prosecutor's office has the ability to move
Ms.
to.
Nelson, Ms. Nelson,
Yes.
that is a decision. You don't like my decision, you appeal my decision. They said they dismiss it, they're dismissing it, period. So they're not gonna bring it back.
Thank you, Your Honor.
You're welcome. The matter is dismissed without prejudice. I just need a dismissal form, please.
I'm just filling it out.
Okay. I think so. I just picked it up. Yeah, I got it. Oh, okay, all right.
If that form could just be emailed to me once it's executed, Your Honor, I would appreciate that.
Okay.
Yes.
Close the hearing.
Thank you.
Oh, thank you.
I can't hear you. Okay. We have 3 persons.
Okay. Who are they?
Jamie, we have Thomas,
All
we
right,
have
Judge.
Franklin.
It's Jamie,
Thomas,
Thomas.
Jamie, Thomas, and Franklin are 3 prisoners. Franklin.
Ms. Getty,
Yes.
this is Frank, Ulysses King,
Uh-huh.
East, and Judge King's at 1:30.
Oh, so we.
So is he gonna do all of them?
No, no,
So we still doing 11:30?
yeah, yeah, we still have to. Because they don't want to get his stuff, even though, unless it's the same complaint.
Oh, okay.
Well, might be different.
Yeah, they don't,
How
yeah.
you doing?
Okay, so.
All right.
Channing,
I'm up to the bridge room. Okay, go ahead, thank you.
Yeah, when it's.
All right, so I got Maurice Turner up first. Comes back.
What's happening?
Oh, Jane, how are you? Jane.
Hey, Kate, hey, Rob, could you get that guy who just came in? Could you get that guy, James, dude just came in?
You the defendant?
No, just call, no, he came, he helped work the courts.
Oh, Jack.
Um. Mr. Pope, your client KPS in 21?
Yes, I believe that's correct.
All right, I don't know if he's gonna arraign it right now. Is your client on?
Yes, he is.
You know, you normally have to go through arraignments. He only does within a week of KPS.
Oh, okay,
You can't log him on.
okay. I'll tell him that.
Now, cause
I'll tell him
now I
that.
gotta locate the file. So what are you gonna do? You wanna try to wait and
I'll just
ask?
I'll contact him and tell him he needs to go through arraignments.
All right.
All right, thank you.
I was gonna see if you can get.
Oh, his client's in the hallway.
Oh, hold on, Mr. Pope, hold on.
What's his client's name? He is.
Wheeler, Marquell. Can you ask, who pulls files down there? Over in criminal, LaDonna, can you just ask LaDonna if, I need this file. Thank you, James.
Madam Clerk, is the Maurice Turner matter going to be heard today?
Yes, Counselor, I have it when the judge gets back.
Madam Clerk, this is Nicole Casca. I'm going to pop into the courtroom where Judge Giles is going because that's, I have a case
Yeah,
up there as well. So I'll be right back.
Right.
Is that okay?
Yes, that's perfect. Thank you.
Thank you.
Just have him wait. Is this him?
Yeah.
He's, Capias, Mr. Polk is on, he's trying to get him arraigned on the Capias, which he should have went through arraignments, but we just gonna see if, the judge will hear it. So I went to go have,
Jordan,
yeah,
come here.
that's what I'm trying to see. Yeah, right. I just hate the way how he waits that. Yeah, it is what it is. Mr. Polk, did you hear me? Your client was here?
Yeah, yes, I did.
Okay,
But
all right. Go ahead.
you said he should go through arraignments. I can have him go through that process.
I mean, it's up to you. I mean, he's here now, so I just had the file pulled, so.
Okay, I'll wait then. Thank you.
All right. This is Capias.
His name is Willard. Willard, oh, okay, Willard.
Is there anyone that has not checked in with me?
Just to make sure this is David West, I left a message in the chat.
I'm sorry?
I'd say this is David West, just to make sure I checked in. I know I left a message in the chat to let.
Oh, okay, yeah, I checked you in. Thank you, Mr. West.
Okay, thank you.
Morning, Madam Clerk. Dennis Whitey checking in for Brent Smith. I'm not even sure if he's checked in.
No, he has not checked in.
Okay, I've not had any contact with him. The phone number I have for him is bad. Sent him a letter with no response yet. So just so you're aware.
So you want to waive, do you want to waive his appearance?
Yeah, I can waive his appearance. It's set for exam and then hopefully get in contact with him to get him in there.
All right. All right, so I'll put you up.
It's
Yes, sir.
David Franklin, attorney.
Oh, did he? Okay.
She's on Zoom, but she also has a couple calls on Miriam.
I can't bring her up. So, Rima.
Yes.
Oh, you're not on, Turner. That's Miss Laura. Okay, that's all right.
Sure. What's going on with that one? So I can let her know.
They're just gonna ask for a jury. She knows, she's on.
Okay.
She's on.
I was set with her back there since
I was just gonna let you know because it wasn't on the docket.
Behind. Oh.
Courtroom 233, Judge Giles. Yes. The exam is at 9 o'clock. What about 9:30? How much time do you need? All right. All right, so is it a way you can call me back at 9:30 to see the status on it? All right, thank you. What's your,
Martin, Mary Martin, Terry,
I know, Mary Martin? No.
or Huntley, right?
Mhm.
Or Huntley.
Joseph Right. Fleming's
Who?
Joseph Fleming, complaint.
Okay. Oh.
So now we got, we got the complaint on Franklin.
Oh, he's not even here. I guess you. I guess the prosecutor can get. You wanna take it? All right, I gotta email. I said, how you feeling? Good, good. APA, right?
Miss Kitty, there's a Jadis Arnold in the hallway too.
Yeah.
He said his attorney's gonna come back.
Yeah, his attorney's supposed, I don't know, I just told him. Cause maybe they're gonna wait.
This is.
Yeah.
I mean, that's the only thing I can think of.
Yes, sir. They're here.
There you go.
What case is the prosecutor,
Okay.
Maurice Turner? No,
No, he's not going anywhere.
Mr. Sawyer?
Yes, good morning, Madam Clerk. I am here with Defense Counsel Jeff Gnecki. We have an exam scheduled for Wednesday, and I think we're going to see about adjourning it.
Okay, that was, what was the name on that one?
Oh, Demario Mathis.
And it's scheduled for Wednesday?
Yes.
Did y'all talk?
We'll get you.
Mario Mathis.
We're witnesses, though.
Which one, this one? Mario Mathis? Oh. Oh, yes, that's wonderful. Yeah, they can come in early. Yeah, oh, yeah, absolutely. Yeah, he was saying.
How you doing there? All right.
Yep, yep, sure can, yes, he would. Yeah, he would. You can approach him, yeah. Yeah. Yeah, I would say approach him.
Yeah.
You can even get him as soon as he comes down. Yeah, he's a little.
That's what.
Okay.
You don't shoot it.
Yeah, yeah. No, she sounded. Come in, right. Hey, excuse me.
All right, I got the Mario Mathis. Is that the one he sent me an email on, I think? That's the one he sent. I think he sent me an email on this one.
Yes, Madam Clerk, I sent an email with that included the flyer for the funeral.
Oh, okay. All right, thank you. I'm printing it out now.
Thank you.
It's gonna be a horrible print.
So,
It just
I got you, sis.
prints horrible. All right. Oh, it's not too bad. Normally it'd be all cut up or something. It's not bad. All right. All right, I got it. Thank you.
Thank you.
Is there anyone else who needs to check in that has not checked in?
I ain't said all right.
Oh, yeah.
What's her name?
So Miss Casca isn't back. I hope she come back by the time it's good. Probably, I'll just-
Madam Clerk, would you like me to text her to come back?
No, because the judge is in the courtroom that she's in, so.
Okay.
She's fine. I'm sure she'll be back when he gets back. All right, so Rima, since I only had these 3 cases to call.
Today?
So when he comes back down, so I'll call these and then I'll, just so I can get,
He's back there.
get them off the Zoom.
He's talking with his counsel right now. Appreciate it. Want to go talk to
And Mr. Polk, I'm just waiting on the file.
Thank you very much.
You can go, Rob. Go ahead, man. You're fine, man. I'll see you later. Yeah, I got you, man. See you later.
You need another one?
For 4 days.
Yeah, I hear you. Courtroom 233, Ms. Giles.
It's gonna be summertime all week.
Oh, man, yes.
I was outside all yesterday and just
Give us. I like that. Enjoy.
Oh, yes, at 9:30, and he is here.
So, Ms. Johnson.
All right. Oh, you're. Huh? Who's gonna do? Well, no, all down. Hold on. I feel like it's a lot going on. Is it because I just been relaxed all Friday?
Yes, I'm telling you. It does go more because you're more relaxed. That's all it is, because you've been.
Oh.
You know what I mean? Coming back at, about 4 days. Yeah.
Good morning. Is there anyone that needs to check in that has not checked in?
I do. Oh.
Your name?
Anthony Roy.
Tell me you're not sure.
Anthony Roy. What are you here for, Mr. Roy?
Okay, I was sent a paper in the mail, 36th District Court, review, court date 4/10/23, 8:35. It says to join Zoom hearing at www.36districtcourt.org, Raymond Alicia, and I cannot get through. I've been trying. They sent me a number 0349-011-3140, and the computer will not accept that number. So
Okay, I don't know what you're doing to log on, but what's the judge's name on there?
it says Raymond Alicia.
What kind of case? Raymond Alicia.
Show her the
What
thing.
type of case is it, sir?
It's disorderly conduct.
Okay, first, you're in the wrong courtroom. I'm not sure what judge that is.
Show her the paper. Can you see this paper for us?
Okay, I can see.
Are you able to see that?
Oh, Alicia. No, that's. I don't think, that's not the judge. That's it looked like an officer. Oh, you're with Evans. You see that R. Evans? That's that's the judge, R.
Okay.
Evans.
Thank you so much.
So when you log on, look for R. Evans,
All right.
judge.
Thank
The
you.
person, the R.
Thank you so
Okay.
much.
Thank
You're
you.
welcome.
Bye.
You're welcome.
Report up front for Franklin.
Yeah, which year? Oh, Miss, what is your name?
Henderson.
Miss Henderson. So Frank Murphy called me on the DSU report that you, requested. He said he's finished with it. It is due today, but he said he's having a computer, error. He's waiting on them to fix it.
Okay,
So,
I'm hoping we won't need it, but,
okay, I just wanted to update so you know.
okay.
He's supposed to call me back at 9:30 to let me know. Thank you.
Thank you.
I had to tell her because I forgot.
Right, because you gotta get back into it, I'm telling you. Yeah.
See.
See, like Rob said, he even done a poll because.
Right.
Yeah. Hey, now, that kid we took off the street, this is attorney? Oh,
Oh, the one in the back?
you wanna,
That's
are we
Mr.
gonna
Cook.
do that first, since it's not a vote?
I can't, I don't have a file.
Oh, I'm saying wait for it. Yeah.
Same one, same one.
Right, until you get the.
And I told him, check him when he called it, but he wasn't on the back. Told me why he came down for it. I said, you need to call your attorney. I'm down here with you.
Right.
My name is Earl Huntley, and couldn't hear nobody talk to me. My nurse came in, and then I had to hang up, so I'm calling back.
Okay, Mr. Huntley, we're just waiting on your attorney, okay?
Okay, so I just sit here by the phone?
That's correct.
All right, thank you.
I'm gonna put you on mute until your case is called, okay?
Okay.
All right, thank you.
So that's our client right there.
Wayne County Jail Division 2, who do you have?
Dwayne Miller.
I'm sorry, your name?
Dwayne Miller.
Oh, Miller. Oh, she called and said she was gonna be next. All right, Mr. Miller, thank you. I have you checked in, okay?
Okay.
Your attorney is running a little late. She did call.
Okay.
Who's not so busy that they could look up the dates for,
You just reviewed it.
All right, calm down.
Yeah. You got this stuff you need to know.
Calm down, Kitty.
Kitty all rested, she better.
So
take it on.
she too rested. That's the thing.
Right. I needed one more day.
Kitty, we all Kitty. You know that too, at 332 here.
Yeah, I see.
That's what.
Did you get it?
The 4 digit, I told y'all. Told y'all, I gave y'all 4 digit.
Did you get it?
Of course I did, no.
Which one was it? I forget.
It was
6291.
Yep. I seen it.
I gave y'all the number.
Sure did.
I
And
said it's
listen,
coming
I
out.
played it,
Did you?
but I didn't play it that.
Did play it that day.
And I overslept.
You ain't the only one.
When my number came out, I had to play it, so I was gonna play it today, that day, and I didn't get there in time. I got home late, I was like this.
Oh, there she is on.
My savings, yeah, I just told her that he was on Zoom. My saving grace is that it wasn't.
Good morning, Attorney Henderson. Are you on Martin?
I am.
Yeah. Yep. Okay, all right, cool. I'm sorry, you say you're on Martin, Ms. Henderson?
Yes, I am.
Okay.
Are we able to have breakout room?
Sure, can I? Okay, I was gonna get your P number, but I'll get it later. All right, put your in for now.
Okay, thank you.
Mr. Martin, accept the invitation to the breakout room, okay? For your.
It's computer generated.
Oh, okay.
Wait, you got a time?
9:30.
Yeah, it's 8:45,
Did I miss it?
Yeah, it's right there. 8-4.
Yeah, you're right.
3-9. 8-4.
8:40. All right. All right, go.
Did Webley come?
Who?
Webley or Winters, they coming in?
No.
And Quinn, okay, that's it.
You ready to go? All right, now is Ms. Castor on. Ms. Castor, did she get back on? We got Maurice Turner is scheduled for the 17th, but the prosecutor is asking for adjournment. Come back on. The judge is on his way down. didn't get any of your P numbers. Rima, I know you're.
Right, soon as they get that out.
Intern, don't have one yet.
Oh, okay. Alice.
P 86590.
You said that's Thomas,
Thank you.
right?
Alice.
So far, we ain't got no witness. Okay.
Right, well, he's on his way down. Miss Irving.
Well, she's not here yet.
Oh, she's not.
Not
Come on, Miss Casca. Leave you alone.
That's for cases.
It's scheduled for 17, right, that they're trying to get a jury.
Yeah.
They're asking for. Well, actually, I'm gonna do that one first. Because I can get the prosecutors involved. You sure?
Can you, do it there?
Huh?
The 17th. So I can just mark it.
Oh, that was missing.
Oh.
Yes, she also has PC.
Oh.
She's on, right, in the breakout room. She said, no.
How you want to do, you're gonna do Maurice Turner and then Jeremy, like, nope.
I want to do Maurice Turner first.
Right, and then nope.
But I don't see Miss
There she is, right
Casca.
there, she's on.
Is she on now?
You look on your big screen, she's there.
Oh, there she is. Okay. Yeah, I'm gonna do her first. I'm gonna do her first, then I got Demario Mathis.
Okay, cool. Yeah.
Because Demario Mathis
Then
is
you
the one.
wanna do that cake is there?
Oh.
You know that. And, we can do the cake is after. The one with
Yeah, Wheeler.
You see it.
What is his name? Carr. I didn't even look. Does Mr. Turner have a lot of charges?
It's so frustrating.
Laura, are you on both cases?
I'm only on the AWEM.
Courtroom prosecutor should be on the other case.
Oh, so Rima, you guys are on the other case. I don't know. Well, she's on the A one, which is this one, but he has two cases. Which I don't have the actual file on that. Oh, yeah, you should be on the receiving and stolen property, receiving and concealing. Maurice Turner Jr. is exam. He's got two cases. She's only on one.
Oh, okay, yeah, I'll do the other one.
Okay. It's just, it's scheduled for the 17th.
Okay.
She's asking for adjournment, so I'm sure you know, we wanted to go together. Oh, I forgot to do this next. We got plenty. Need some more. I think it's low.
Okay. Court is now back in session.
You took your pen upstairs, didn't you? You got one? You ready?
I got one. Yep, I'm ready.
Parties ready? Maurice Turner Jr. Calling case number 2355526. The people of the state of Michigan versus Maurice Turner Jr. Defendant is charged with count 1, assault with intent to murder, count 2, carjacking, count 3, assault with intent to do great bodily harm, less than murder or by strangulation, count 4, weapons, firearms, possession by a felon, count 5, weapons, felony, firearm, count 6, weapons, felony, firearm, count 7, weapons, felony, firearm, count 8, weapons, felony, firearm, habitual offender, second notice. Also calling case number 2355115. The people of the state of Michigan versus Maurice Turner Jr. Defendant is charged with count 1, stolen property, receiving and concealing motor vehicle, count 2, controlled substances, possession, cocaine, heroin, or another narcotic less than 25 grams. These matters are here on adjournment hearings.
Good morning, Your Honor. Lauren Nersessian on behalf of the people, P67104. I am here on the matter that is the assault with intent to murder. That is case number ending in 526.
Good morning, Your Honor. Remax with on behalf of the people. I'm here on the second matter, the stolen property.
And good morning, Your Honor. May it please this most honorable court, Nicole Casca, P55470 on behalf of Mr. Turner. Your Honor, Mr. Turner is in the Wayne County Jail. He's in the infirmary unit where he's under medical care. It's a little bit challenging to transport him for video due to his condition. So I'm going to be asking the court to allow me to waive his presence today.
Waive his appearance for purpose of this hearing.
Thank you, Judge.
For the day?
No, judge is set for the 17th.
Okay. All right. What's your issue?
Judge, I did file this motion on March 24th, and Ms. Casca did also sign it, so it was a stipulated motion to adjourn. On the 17th, I did not realize that when I set this exam, I already had an exam set for 10 o'clock that day. So I'm just literally double booked.
And Judge, there's no objection from defense, and I would ask that both cases be set for the same date. And there might still be an issue with being able to bring my client, if my client is not able to bond out, bringing him over from the infirmary due to his medical condition.
You may have to be on Zoom. Is there an issue with that?
Not for the people, no.
My issue would be that I wouldn't be able to talk with my client in a meaningful manner to be able to conduct the exam. And I think it's going to take the exam longer than to be conducted.
You know how long he's gonna be in the medical division or unit?
I don't know how much longer he's going to be there. They're trying to render him medical care, and they're also facilitating getting him to and from the hospital as well for the routine, the checkups that he needs to do with the respiratory specialist and the surgeon. So I don't know, Judge.
Yes, yes.
We have one 23.
On the 25th, nothing. 26th, just one complicated.
April 25th at 9 and 9:30. 9 and 9:30.
Sounds good, Judge. Thank you.
Judge, can we do the 26th? I'm in circuit court that morning with several matters, one being a hearing where we're taking testimony.
April 26th, 9 and 9. All right.
9 and 9:30. Thank you, Judge. That works well for the defense.
Likewise for the people. Thank you, Judge, and thank you, Ms. Casca.
You're welcome.
All right. Yeah, both of them. I think so. Yeah, one we'll do at 9, one other will do at 9:30.
Okay. Thank you. Yeah, well, that's Mr. Franklin. He's here. Miss Henderson is here too. She's on Zoom right now, but I think she's in the hallway too.
Are we doing the?
Oh, we still got PCC judge.
Okay. All right, you do.
Parties ready on Demario Mathis? This is, calling case number 2356001, the people of the state of Michigan versus Demario Mathis. Defendant is charged with count 1, robbery armed, habitual offender, for notice. Also calling case number 2356000, the people of the state of Michigan versus Demario Mathis. Defendant is charged with count 1, stolen property, receiving and concealing motor vehicle. Count 2, police officer fleeing 3rd degree, habitual offender, for notice. This matter is scheduled, this matter is here on adjournment hearing. Scheduled for Wednesday. Asking for that.
And good morning, Your Honor. Brendan Sawyer for the people, P83033 on the armed robbery case. Uh-oh.
Prosecutor on the other case.
Yeah, it's the courtroom prosecutor on the receiving concealing, but I can stand in for them as well, I suppose.
Sorry, Your Honor, do you mind if we on behalf of people?
And, oh no, I think we've lost defense counsel.
Yep.
Yeah.
He's not. Oh, no, he's on. Jeff Canoche. Connected.
Mr. Konecki,
Yes. All right. I'll be here.
that's not showing up. So it's not on mine.
Oh, I see in my mind. Want me to recall it?
Yeah.
Party's ready. I'm Brent Smith.
Ready.
Calling case number 2356203, the people of the state of Michigan versus Brent Smith. Defendant is charged with count 1, stolen property, receiving and concealing motor vehicle. This matter is scheduled for a probable cause conference.
Good morning, Judge. Alex Ryan on behalf of the people, P number P86590.
And good morning, Your Honor. Dennis Whitey, P79560 on behalf of Brent Smith. Your Honor, I would ask to waive his appearance for purposes of this PCC as I've not had an opportunity to speak with him. The phone number I have for him is not valid. I sent a letter, but have received no response. I'd just like to schedule an exam date so I can find him.
All right, we'll waive his appearance for the purpose of this hearing. Set this matter for exam on April 17th at 9:15.
April 17th at 9:15, Judge. Thank you.
All right, thank you.
Party's ready. Oh, Mr. Wheeler.
Okay, it's Mr. What's that, Killer?
Oh,
Oh,
yeah, he's on.
okay.
Judge, Mr. Wheeler is here on the KPS. Yes.
They gotta come in person.
Huh?
Yes. Huh? Is it? Oh, okay. Attorney's on.
Mr. Polk is on, yeah.
Oh.
That's fine.
Calling case number 2059567, the people of the state of Michigan versus Macari Wheeler. Defendant is charged with count 1, weapons carrying concealed. This matter is scheduled, if this matter is here on the KPS warrant.
Good morning, Judge. Alex Ryan on behalf of the people, P number P86590.
Good morning, Your Honor. May it please this honorable court, Larry Polk on behalf of Macquarie Wheeler, who is present there in court. Mr. Wheeler, state your name for the record.
Macquarie Wheeler.
Judge, this matter comes before you. I'm asking the court to recall the KPS warrant set for Mr. Wheeler and attempt to get this matter back on track for a preliminary exam.
All right, your client misses exam date.
I believe there was some confusion, Judge, in reference to what he needed to do. We thought I was not the attorney of record at the point in time of this case. It was assigned counsel, and he just has not followed through in terms of, I guess, what he needed to do. He contacted me once he found out that this matter was still open, and we're here today trying to get him back on track.
I have a question, your client.
Yes, sir.
First station name again, please, for the record. Macari Wheeler. Wheeler, you were supposed to be in court on, it was June 29th.
Yes,
Where were you?
I was going through another case. As far as I had another case I was going through. I was just had a lot going on at the time.
You understand, you can't keep up with your calendar. I can.
Yes, sir.
I make it real convenient. You just be sitting in Wayne County Jail to do this. Is that what I have to do?
No, Your Honor.
We're gonna set aside a capias. I'm gonna reinstate the original personal bond. It won't happen again, notice. Do you understand?
Yes,
To make sure you're here.
yes, Your Honor.
All right. Polk, are you available? April 17th. At 11 o'clock. At 11:15.
1 second, please, Judge. Let's see. I am not, Judge. I apologize. I have a matter in Sterling Heights at 9:30, and then I'm in Mount Clemens at 12:30.
All right. About April 18th at 9:30.
Yeah, I can do that, Judge. The 18th at 9:30.
Mr. Will, you understand your next court date?
Yes, Your Honor.
See you back then.
Thank you very much, Judge, for your consideration, and you and your staff have a great day.
Thank you, you too. Take care.
Yep, sure. All right.
Exam day. Yeah, in person.
All right, you got your date, right? Yeah, 9:30 here. Okay.
Calling case number 2258612, the people of the state of Michigan versus Raymond Thomas. Defendant is charged with count 1, malicious destruction of a building, $1,000 or more, but less than $20,000. Count 2, retail fraud, 3rd degree, habitual offender, 4th notice. This matter is scheduled for examination.
Good morning, Judge. Alex Manning on behalf of the people, P number P86590.
Good morning, Your Honor. Sally Irwin on behalf of Ramon Thomas, who stands to my right.
Ramon Terry Thomas.
Thank you, sir. All right, you ready to proceed?
The people are unable to proceed as we do not have the necessary witnesses to be able to move forward right now.
Judge, I'm moving for dismissal.
Matter dismissed without prejudice.
Thank you, Judge.
Thank you, Judge.
Welcome.
Step this way.
Ready on Dwayne Miller?
Good morning.
Yes, ready.
Calling case number 2356144, the people of the state of Michigan versus Dwayne Miller. Defendant is charged with count 1, count 2, police officer assaulting, resisting, obstructing, habitual offender for notice. Also calling case number 2356146, the people of the state of Michigan versus Dwayne Miller. Defendant is charged with count 1, assault with intent to do great bodily harm, less than murder or by strangulation. Count 2, assault with a dangerous weapon, felonious assault, habitual offender for notice. These matters are scheduled for probable cause conference.
Alex Ring on behalf of the people, P number P86590. Good morning, Judge.
Good morning, Your Honor. Rebecca Tiapo, P62311, on behalf of Mr. Dwayne Miller, who is appearing via Zoom, it looks like from the Wayne County Jail.
Miller, can you state your name for the record, please?
Dwayne Miller.
Thank you, sir.
You're welcome.
All right. Info, pleasure.
Yes, Your Honor. I don't believe that I have received the discovery on either of these cases. I would like to request in-person preliminary exams in both matters. And I also would like to address bond.
All right. Exam reset for April 17th at 11:45.
Your Honor, I'm actually starting a jury trial that day at circuit court. It should go the entire week. So would there be something available the 27th or the 28th?
That's putting it off too far. And it's going to just that week.
Well, so from the 17th through the 24th, I have one trial, and then a second jury trial on the 25th and the 26th. So I guess if there would be something sooner, like maybe the 13th.
We'll get your witness in here by the 13th.
That would be, I'll leave it up to the discretion of the court, but the 13th, I probably wouldn't too early.
Civilian witnessing or police witness?
These will be, we do have civilian witnesses.
Okay, what we got on the 27th?
Nothing on the 20. You said the 27th, Judge?
Yes.
Nothing.
All right, April 27th at 9. Both cases, one after each other.
Your Honor, could I have something a little bit later? I have several 9 o'clock matters in the circuit court. Early afternoon, if possible.
Set it for 11 o'clock.
All right.
All right. Yes.
And may I address the bond, Your Honor?
Second. Any arrest action. Of course. All right, Ms. Tampo, on the one case, he already has a personal bond. On the second case, he already had a bond redetermination hearing in front of Judge McConicle on March 31st, 2023.
Is that the 15,000, 10%, Your Honor?
No, it's 5,000, it was lowered to 5,000, 10%.
Would the court consider a personal bond with the GPS tether?
You'd have to show me that the information you're giving me now is different than the information Judge McConicle had. You know, unless you can do that, I can't reconsider the bond.
I understand.
Okay.
Okay, thank you so much, Your Honor.
I can put in for a DSU report.
Yes, please, Your Honor.
All right, that'll conclude the hearing.
Can I put a matter on
Thank
the
you, Judge.
record? All right, can I put a matter on the record real quick?
Put a matter on the record?
Yes, with the issue of discovery. Did she say she has discovery or not has all
I
discovery?
think she said she does not.
I still need the discovery, please, on both cases.
Discovery has been sent, but I'll resend it.
All right.
Thank you.
All right, thank you.
Calling case number 2356196, the people of the state of Michigan versus Jadis Arnold. Defendant is charged with count 1, robbery armed. This matter is scheduled for a probable cause conference.
Good morning, Judge. Alex Werner, on behalf of the people, P number P86590.
Morning, Your Honor. William Winters, the 35975 on behalf of Mr. Arnold. I don't know whether the court wants us at the podium or.
Yeah.
You don't care. It's different, Mr.
All right, can you state your name, please, for the record?
Davis Arnold.
Thank you. All right. Mr. Winters?
We're demanding an exam. Your Honor.
All right. Available the 17th at 11:45.
You know, it's conceivable that I could have a trial that day, perhaps either the 19th, the 20th, perhaps.
The 19th, 9 o'clock.
That's perfect.
All right, anything else?
Yes, Your Honor. First of all, I think Mr. Arnold understands the severity of the charges he's facing. He's on an electronic monitoring system. It's 24-hour house arrest, from what I understand. He's got a check stub that shows, I haven't shown it to the assistant prosecutor, sorry. He's got employment. What he's asking for is just permission to travel to and from work and during the course of employment.
What should be heard?
I think with this matter dealing with armed robbery, I think the bond should remain the same. But I leave the discretion up to the court, what they determine what the situation with the work. I would like them provided the proof of employment if the court decides that that is appropriate, but the people would like the bond to remain the same though.
We're not asking for change in bond, it's just asking for change in the other.
As it relates to the tether, then the people would like, again, with the charge being armed robbery, we'd like the tether to remain the same. But we leave the discretion up to the court.
Arnold, where are you working and what hours, what days?
I work at DMS, Detroit Manufacturing System. It's off Schoolcraft and Artesian. And I work a 4-day shift on, I work Friday to Monday. So Friday, Saturday, Sunday, and Monday. It's a 12-hour shift, so 6 to 6. But on Fridays, I have to be at work at 6 in the morning, no, 6 in the afternoon, and to 6 in the morning. Then 6 in the afternoon to 6 in the morning on Saturday as well. And then on Monday, it goes from 6 in the morning to 6 in the afternoon. So they change it.
All right, court's gonna amend the tether requirements to allow you to go to and from work. We'll give additional hour for transportation, back and forth each way. You're gonna have to provide some documentation to the tether unit from your employer showing exactly what hours you work.
Okay,
All right.
I'll text it on me right now.
Take it over to the tether.
Okay,
Yeah, we gotta take it to them.
okay, thank you.
Need it on the bond.
Yeah, I need the, yeah.
Here you go.
Mr. Winters, need you, fill out the bond form, please.
Thank you very much, Your Honor. Always nice seeing you and your staff.
And you too, take care.
The same as well.
Nice day.
You too, take care.
Ready on Demario Mathis? Calling case number 2356001, the people of the state of Michigan versus Demario Mathis. Defendant is charged with count 1, robbery armed, habitual offender for notice. Also calling case number 2356000, the people of the state of Michigan versus Demario Mathis. Defendant is charged with count 1, stolen property, receiving and concealing motor vehicle. Count 2, police officer fleeing, 3rd degree. Habitual offender for notice. Matter scheduled for an adjournment hearing.
Good morning, Your Honor. Brendan Sawyer for the People, P83033 on the armed robbery case.
May it please the court, Neighborhood Defender Service of Detroit by Jeffrey Kanaki, P64800 on behalf of Mr. Mathis on both matters, Your Honor.
Good morning, Your Honor.
All right.
Good morning.
Your Honor, we're requesting an adjournment. I sent in a flyer. My client contacted me late last week and indicated that his father had passed away and the arrangements are set for Wednesday and Thursday of this week. We're asking to adjourn the exam scheduled for 11 a.m. on Wednesday so that Mr. Mathis can focus on his family and the funeral arrangements, handling those things.
And there's no objection from the people.
Oh, 14.
Is it 14th and the 13th?
No, that's. All right. How about Wednesday, April 19th?
Judge, I'm not available the 19th or the 20th. I could do the 21st, the 18th, or the following week, Your Honor.
I'm not even putting it all too long now. We have to get this done within the time limit. All right, so you do the 20th?
No, the 21st, Your Honor. I can't do the 19th or 20th.
All right, 21st at 9:30?
Perfect, Judge. Thank you.
Works for me. Thank you.
All right.
Thank you. Everyone have a good day.
All right, you too.
Thank you.
Sorry, yeah, we see the second.
21st at 9:30.
Parties ready on David Morgan. Calling case number 2355972, the people of the state of Michigan versus David Morgan. Defendant is charged with count 1, controlled substance, delivering, manufacturing cocaine, heroin, or another narcotic less than 50 grams. Habitual offender for notice. This matter is scheduled for examination.
Good morning, Your Honor. Rima Fruit on behalf of the people.
Good morning, Your Honor. Attorney Samar Faraj, attorney on behalf of Mr. Morgan, who appears in person. Mr. Morgan, can you please state your name for the record?
Yes, David Morgan.
Morgan, just so you know, in the future, I don't do sweatshirts or t-shirts, any of that in my courtroom. Dress the court, all right, shirt with collar, all right? Thank you.
Judge, at this time, the people are unable to proceed. The necessary witness in this case did not show up.
At this moment in time, Your Honor, we're asking the court dismiss the charges against Mr. Morgan with prejudice for the complaining witness's failure to show up.
I'm not dismissed with prejudice. I haven't heard the case. I'll dismiss it without prejudice. All right, now it's dismissed. Thank you.
Thank you, Your Honor.
Parties ready on. But Judge, we still got 3 more PCCs, but no attorney, so I'm getting ready to call over there after.
Mr. Franklin, step on out, please.
Oh, one has got 2 dependents on it. West and Martin are on the court.
I'm ready, Mr. Mark.
I know, I'm waiting on the co-defendant attorney. Okay, parties ready on David Franklin, calling case number 2355500. The people of the state of Michigan versus David Franklin. Defendant is charged with count 1, assault with a dangerous weapon, felonious assault. This matter is scheduled for examination.
Good morning, Judge Alex Warren, on behalf of the people, P number P86590.
Good morning, Your Honor. Attorney Cindy Henderson, P84839, appearing on behalf of David Franklin.
Franklin, can you state your name for the record?
David Franklin.
Thank you, sir. There you go. Ready to proceed?
Your Honor, it is my understanding that this time we are going to waive the exam in this case.
The people have no objection for that.
Right. I told her she didn't call.
They didn't,
All right, Mr. Franklin, can you stand up, please? Can you state your name again, please?
David Nathaniel Franklin.
Franklin, I understand that you have a statutory right to preliminary exam with statements show by probable cause a crime was committed and probable cause you had something to do with committing that crime. You understand that, sir?
Yes.
Anybody promise you anything or threaten you in any way to waive your right to preliminary exam?
No.
You waive your right freely and voluntarily after having opportunity to talk to your attorney about it.
Yes.
And you signed the waiver of examination form.
Yes.
All right, quote, find that you freely and voluntarily waive your right to preliminary exam at a found over Wayne County Circuit Court Criminal Division for arraignment on the information, which will be April 17, 2023 at 9:00 a.m. All right, you have another case?
yes.
Your Honor, he does have another case, if it is possible, you would like to address bond in that case, or if you prefer that we address bond in both cases after the second matter, then we would like that.
Well, let's get a second matter first.
Calling case number 2355934, the people of the state of Michigan versus David Franklin. Defendant is charged with count 1, assault with a dangerous weapon, felonious assault, count 2, weapons felony firearm. Matter scheduled for examination.
Good morning, Judge Alex Warren, on behalf of the people, P number P86590.
Attorney Cindy Henderson, P84839, on behalf of Mr. David Franklin. Mr. Franklin, take your answer right, please.
State your name, sir.
David Nathaniel Franklin.
All right, you ready to proceed?
The people are ready to proceed.
Prior to proceeding, we will request that Mr. Franklin's wife be allowed to enter the courtroom. If Mr. Franklin's wife, Shelley Franklin, typically he cares for her, he's her caregiver, she is present in a hall. If the court would allow her to be present, I would just go and get her.
She can attend the proceedings on YouTube.
Okay, thank you.
Are you with us?
Court call first witness Joseph Fleming.
Joseph Fleming or Joseph Franklin?
Joseph Fleming.
Give your name, make sure they step forward, Judge.
Hello.
Hi.
My name is Joseph Fleming.
Okay, your last name F-L-E-M-I-N-G.
Two M's, I-N-G-S.
Two M's.
Yes.
Thank you. Face the judge.
Joanne. There are firms, but you don't, you know, you self, you got.
Yes.
Put a door towards you, have a seat.
Joseph Fleming.
Let me, just let you know, in the future, I'll do sweats in my courtroom. Okay?
What'd you say?
I'll do sweats in my courtroom.
Okay.
In the future, if you please dress for court. And your
Okay.
shirt with a collar.
Okay, I'm sorry.
That's all right.
I thought I was gonna be on Zoom. I'm sorry.
It's all right. Just wanted you to know.
All right.
All right, also, okay, you're gonna be asked a series of questions. First by the prosecutor, then the defense attorney will ask you some questions, and I may or may not ask you questions, all right?
Yes.
You have to answer all your questions out loud verbally using words. You just can't say, or shake your head,
Yes.
all right? Also, when you ask a question, I need you to listen to that question and just answer that question and stop. If it's a yes or no type question, just say yes or no and stop. If they need additional information from you, they'll ask you another question, all right? You all have a tendency, when you're talking about something that's been traumatic, you have a tendency to ramble.
Right.
You know, we'll say, this happened, and this happened, and this happened, and this happened. You know, we want to get it all out, so we, you know, kind of spread it out. Well, problem with that is I know nothing about this case. Everything I know about this case is his name is charged with. Now I know your name, that's all. I get all my information from what happens in this courtroom. That's why we proceed one question, one answer at a time. That way I can understand it, okay?
Yes.
I can make the right decision.
Right.
Okay, you may proceed. Thank you.
Mr. Fleming, can you please state your name for the record again?
Joseph Fleming.
Thank you. Mr. Fleming, were you at the location 9391 Rochester Street, Detroit, Michigan, in the county of Wayne?
Yes.
And you were there at that location on January 9th, 2023?
Yes.
Describe to me what happened on that day.
I just got home from work. I have dogs live in the house and I let them out to use the restroom. And I have big fence around the house with locks on the fence, and I was out with my dogs and I supervised the dogs and let them come out and use the restroom because they live in the house.
Perfect. So when you were done with the dogs, what else did you do next after that?
Kids was coming down the street, so I called my dogs to come in the house. And the gentleman, Franklin, he was parked right across the street. And
Can you identify the defendant in the courtroom today?
Yes, he got a green shirt on and he's right in back of you.
Please let the record reflect that the witness has identified the defendant.
Yes.
Thank you. Continue with what happened.
Okay.
Hold on. The record was over here, but. All right, go ahead.
Okay, so.
Proceed by question and answer.
Yes.
Please.
Explain to me then, when you ran into Mr. Franklin, what happened
I
then?
didn't say you ran into Mr. Franklin. That's not the testimony.
When you saw Mr. Franklin, explain to me what happened.
So Mr. Franklin, he jumped out of the car and go cussing at me. And I had a couple words with him and I pulled my dogs in the house and he pulled a shotgun out. I was pulling my dogs in the house and he pulled out a shotgun and pointed at me.
When he pointed the shotgun at you, how did that make you feel?
I was feared for my life.
And how did you know that that was a shotgun?
I'm looking right at him. He cocked it, looked, and pointed at me.
Did he make any communication to you with that shotgun?
He called me all types of names and he pointed it towards me, and my heart was about to pump out of my chest.
So when you went back into the house, did anything happen in next?
Yes, I was calling the police at the same time, and the police came up.
No more questions.
Good morning.
I'm just gonna ask you a couple follow-up questions. You indicated that you were outside with your dog that day,
Yes,
and you said you had a big fence.
yes.
How big was the fence?
It's probably,
Irrelevant.
Your Honor, the relevance is in regards to whether or not the dog had the ability to get over the fence, in regards to this different fence.
There's no testimony regarding that. So what's the relevance as to these charges, that issue for a probable cause hearing?
Your Honor, I anticipate that Mr. Clement is going to testify that there were statements made by Mr. Franklin in regards to the dog, and why it is that he may or may not have had a shotgun.
No. I want something else regarding that fence. I'm not allowing a question regarding the fence.
Okay.
That has something totally different to do with it.
Okay.
And this is not trial, so I'm not gonna conduct a trial here.
Understood, Your Honor. Mr. Clement, you indicated that you and Mr. Franklin exchanged words,
yes.
and exactly why were you exchanging words?
Cause the kids were coming down the street, I was getting my dog, and he jumps out of the car hollering and screaming and cussing at me.
Can you recall what he was hollering and screaming about?
About my dogs and cussing at me.
So you all got into an altercation about your dogs.
Yes,
More specifically, what about the dogs?
about my dogs being outside.
And he got a problem with them being outside,
He's got a problem with everything.
but he had a problem with the dog being
Yes,
outside at
yes,
that time, right?
Yes,
And as you all were exchanging words, did Mr. Franklin tell you that he would shoot the dogs?
yes,
And during this time, the entire encounter, he had a shotgun, is that what you're saying?
yes.
So he got out of the car, and he already had a shotgun.
He got out of the car and got the shotgun.
Got the shotgun from where?
I don't know, I was terrified. I'm trying to get my dogs.
About
He
how
come
much
out,
time,
he come out with a shotgun.
come out of where with the shotgun?
He got in front of his car and went back to his car.
And that's when he told you to shoot the dogs.
Yes.
No further questions, Your Honor.
When he got the shotgun, did he point it at you?
Yes, he did.
No more questions.
Your Honor, if I could have a brief, moment just to clarify.
Sure.
Mr. Clement, you indicated that he pointed at you at that time were the dogs near you,
Yes,
and that's when he made the statement that he'll shoot the dog, correct?
yes.
Thank you.
Anything else?
Nothing further.
Nothing further.
All right, you step down. Thank you.
All right. Thank you, Honor.
You're welcome. Outside. Anything else?
No, Your Honor.
Defense? Anything else?
No, Your Honor.
Witnesses?
No witnesses, Your Honor.
Motion?
People motion bound over count one and count two.
Your Honor, at this time, we would ask that the charges be denied. I know we've heard testimony from Mr. Clement himself that at the time of the alleged incident, that Mr. Franklin pointed a gun and indicated to him that he would shoot the dogs. In regards to.
Counsel, how do you get by the fact that he pointed the gun in his direction? He said he was in fear of his life. what his intent was is an issue for trial, not for a probable cause hearing.
Your Honor, it would be my understanding that, Mr. Fleming testified that Mr. Franklin pointed the gun
In his
in
direction,
his direction at the
he was
animal.
in fear. Those are the elements for felonious assault.
Your Honor, that is one of the elements for the felonious assault. An additional element is that there was intent to harm Mr. Fleming, which there has been no testimony in that regard. Instead, what Mr. Fleming has testified is that he intended to shoot the dogs.
So you point a shotgun in the person's direction. You don't think there's an intent to harm that person? Even if I say, I'm gonna shoot your dog, and my dogs are standing right next to me, what's gonna happen with that shotgun?
Your Honor, in that regard, in regards to what Mr. Franklin's intent was, Mr. Fleming testified that it was to shoot the dogs. In regards to the
Now, you're avoiding my question. I'm looking at the facts of this situation. It was a shotgun.
Your Honor, in regards to the element that fear may have been created, I understand that you're saying that if a gun is pointed in that direction.
A shotgun.
Correct, Your Honor. I understand that you're saying that Mr. Fleming may have been placed in fear, but another element is also that Mr. Franklin intended to harm Mr. Fleming, which Mr. Fleming testified today that that was not the case, Your Honor.
No. He did not testify that was not the case.
He testified that Mr. Franklin indicated to him that he would shoot.
You
his
asked
dog.
him, did your client say that? He said, yes. Your client said a lot, and you didn't go into all the rest of the things he said. So I don't know what else he said.
Your Honor, there's been no testimony presented from Mr. Fleming that Mr. Franklin intended to harm him in regards to any questions that I may have asked.
He was put in fear, that's not enough, counsel. Based
Okay,
on the
Your Honor.
facts of the situation.
Understood, Your Honor. Again, I'll just place on the record that one of the elements requires that Mr. Franklin intend to harm Mr. Fleming, and no testimony has been presented of that, Your Honor. Nothing further.
Anything further?
Nothing further from the people.
Right, court having heard the testimony and arguments finds as follows. That on January 19, 2023, the witness, Mr. Joseph Fleming, was at his home at 9391 Dorchester. He let his dogs out. He saw the defendant get out of his car. He saw the defendant jump out of his car. He had a shotgun. He was cussing, howling, and screaming at him. At one point, he said he would shoot the dogs. He said he was in fear of his life. He pointed the gun directly at him, which is more than enough. That, the fact that he pointed the gun at him, that's the assault in and of itself right there with a shotgun. Even if the only thing he said was, I'm gonna shoot the dog, it doesn't matter. It's a shotgun. It's gonna spray everywhere. So court finds that, and being that it was with a firearm, court finds that the felony enumerating complaint warrant did in fact occur in the city of Detroit. Probable cause exists to charge this defendant. It'll be bound over to Wayne County Circuit Court Criminal Division for arraignment on the information, which will be April 17th at 9 o'clock. Great, ma'am, you have another motion?
Yes, Your Honor. At this time, we would like to address bond. We have bond motion, based on the probable cause conference. We filed that motion in regards to having this bond amended to a personal bond. There was a bond redetermination hearing done by, it was scheduled before Judge McConnell, however, had handled that matter. We did submit the transcript regarding that hearing to court. It was emailed along with a motion and a brief in regards to changing bond. At the bond redetermination hearing, bond was denied modification due to the fact that Mr. Franklin did not have another address to reside. We do have another address where he is able to reside until the case is resolved, Your Honor, and you're able to provide that information to the court.
Hold on a second. You've seen the bond motion, counsel?
I have not.
Your Honor, we filed it with the court, and we also
provide a copy to them?
We provided via email.
That's a yes or no question, counsel.
Yes,
You did, Thank you.
Yes.
Your Honor, I have had the chance to look over, defense counsel did send an email, I did look it over, and looking it over, I feel that this situation, that bond should remain the same, with the protection of the community, and the people in the public, dealing with this issue, a matter of having a gun. I think that bond should remain the same, it should go unchanged.
Where would you plan to live?
Hunter, he will be residing with his son. The address would be 5937 Audubon, Detroit, Michigan 48224. And I have confirmed that with both his son and his wife, who is president of the state.
Oh, Audubon, that's east side or west side? Wait, is that near the Dorchester address?
No, it's at East West.
I hear
I got a bunch of folks talking.
So that's on the east side.
Oh, yeah, I thought all about it.
Yeah.
Sorry. Right. Right, court's gonna, reduce the bond to 25,000 personal bond. No contact, with the defendant, and with the, witness, Mr. Fleming. And there'll be nowhere near 9391 Dorchester Street. You understand that, sir?
Yes, Your Honor.
So you understand no contact means no contact. You can't contact. You can't have anybody else contact. That's in person, by telephone, text, email, Facebook, Twitter, whatever. You can't put anything about this incident on social media. Do you understand that?
Yes, Your Honor.
If you happen to be in the neighborhood, you go to the neighborhood gas station or the corner store, and you see Mr. Fleming, it's your obligation to immediately turn around and walk away, leave. It's not his. Do you understand that?
Yes, Your Honor.
All right, court's ruling.
Your Honor, would that rule stand for both this case and the other case that we mentioned prior to beginning the exam for this case? Both bonds. were
I don't know anything about the other case and why I don't have.
Your Honor, the motion was
That
filed.
ruling stands for this case. Let me see the other case.
Do you need the motion? Is that your right?
No, I don't need the motion. I read it. I need the file.
Oh, this is Franklin, right?
Yes. People wish to be heard on this?
In this matter with this bond, if it is allowed to go on personal bond, no contact with the victim and being able to protect the victim is the people's importance of this, and if bond is not reduced or leave it to the discretion of the courts.
Your Honor, Mr. Franklin understands that he has had no contact with the complainant about this case and the other case, and he is to be nowhere near that address, Your Honor. He will reside with his son.
All right, I'll reduce the other bond to 25,000, 10%, but I want to tell them, I want to make sure. I didn't realize it's the same victim in both cases. Well, they have some issues going on between them. And I want to make sure they stay apart. You understand that, Mr. Franklin?
Yes, I do, Your Honor.
You understand that I get even a whiff of anything that you try to make contact or try to make contact with Mr. Fleming? You understand what's going to happen?
Yes, Your Honor.
Okay. I just like to make sure things are perfectly clear.
Yes, Your Honor.
All right.
Step this way, sir.
Your Honor, if I might just have a chance, just to provide some information regarding the $25,000, 10% bond. It's my understanding that Mr. Franklin is currently unemployed. He would not be able to post that cash bond. In regards to his criminal history, he does have a relatively lack of criminal history.
Wait, that's a 10%. No, it's not. I thought it said personal bond. It's a personal bond with a tether.
Okay, Your Honor, thank you.
That's what I thought it said. I need a line reduction on both cases.
Thank you.
Thank you, Judge.
Well, thank you, John.
You need another vote on the other one, Judge?
Yes.
Hi, how you doing? Good.
I'm afraid I am on Earl Hunley. I am the late party.
Girl, yeah, I just called.
Yeah, my apologies, I was booked in several places at once and had to be here for an in-person hearing, so I apologize for being late.
All right, next time.
What's your
call? Oh, we have small.
I understand, and I apologize, I've been running all over the place. P number 82125.
82125?
Yep.
Okay, your client is on Zoom. All right, ready on our last, piece.
Last PCC?
Two, well, three. One of them is two defendants.
Oh, say it again?
And then I got, exam ready on Smith. Ms. Henderson, I'm gonna call yours. Parties ready on David West. Parties ready on Miriam Martin. Calling case number 2356206, the people of the state of Michigan versus David West. Defendant number 1 is charged with count 1, weapons carrying concealed. Count 2, weapons, firearms, possession by a felon. Count 3, controlled substance, possession, cocaine, heroin, or another narcotic less than 25 grams. Count 5, weapons, felony, firearm. Count 6, weapons, felony, firearm, habitual offender for notice. The people of the state of Michigan versus Miriam Martin. Defendant number 2 is charged with count 4, controlled substance, possession, cocaine, heroin, or another narcotic less than 25 grams. Habitual offender for notice. This matter is scheduled for probable cause conference.
Good morning, Judge. Alex Wang on behalf of the people, P number P86590.
Good morning, Judge. Christopher Quinn, P69483, appearing on behalf of Mr. West, who's also appearing via Zoom and consents to appearing via Zoom.
Mr. West, can you state your name for the record, please? Yeah. Mr. West,
Yes,
can you state your name for the record?
David Ellis West Jr.
Thank you, sir.
You're welcome.
Attorney Cindy Henderson, B 84839, hearing on behalf of Miriam Martin.
Mr. Martin on, or you waiting his appearance?
He was on the Zoom before I did the hearing, so I think you should.
Mr. Martin, Mr. Martin, can you state your name for the record, please?
Marion Christian Robert Martin.
Thank you. All right, we'll send this matter for exam.
Yes, there's this one discovery issue. I did receive a paper discovery, Judge. I have not received any audio, video, body cam, dashboard, any that dash cam, anything like that. I did receive a paper though.
Who's his client?
Mr. West.
Mr. West. Digital was sent on April 5th, but I will resend the digital.
All right. You hear that, Mr. Quinn?
Yes.
Okay, thank you. All right. Also, just in case, get a, if you could send in a discovery order, or I'll sign it, because I have to have that discovery order in order to act on it.
Understood.
All right, available, April 17th at 11:45.
April 17th at 11:45 works.
For exam.
Your Honor, I do have 3 other exams scheduled for that morning. They are anticipated this time to run. The one prior to that will be at 10:30, and I am not sure how long that will run. We are able to move it to the 18th.
What is it for? What's the charge on 10:30?
There are 5 different counts: possession of controlled substance being 2 of them, CCW and felon in possession.
You available, Mr. Quinn?
What time is available on the 17th?
11:45?
Yeah, I'm available at 11:45, Judge.
Okay. All right, anything else?
People.
All right, that concludes the hearing.
So we're set for 11:45 on the 17th?
Yes, sir.
Okay, thank you. All right, see you then. Good to see you, Judge.
All right, good to see you too. Take care now.
Excuse me, Your Honor.
Yes, sir.
Is the matter with Marianne Martin finished?
Yes, we're finished. You can sign off now. We'll see if you're in person in court on April 17th at 11:45.
Okay, this is Frank Murphy, correct?
No, 36th District Court. And it's
Okay, thank you.
courtroom 233.
Okay, thank you. You have a good day.
You too.
What'd you say? Yeah, I don't know. Let's get this out.
Huh? No, I'm doing Huntley first, because Smith is a whole, right? I got one more, PCC. He was? Ready, Council? Calling case number 23-56055, the people of the state of Michigan versus Earl Huntley. Defendant is charged with count 1, assault with a dangerous weapon, felonious assault, count 2, weapons, felony, firearm, habitual offender, third notice. This matter is scheduled for a probable cause conference.
Good morning, Judge. Alex swearing on behalf of the people, P number P86590.
And good morning, Your Honor. Good morning to your staff. Neighborhood Defender Services by Ken Riggins, P82125, on behalf of Mr. Earl Huntley.
So Huntley already waiving his appearance.
Yeah, it was my understanding Mr. Huntley was on Zoom.
He's on Zoom.
Mr. Huntley, can you state your name for the record, please?
He's on the phone. He hasn't muted.
Mr. Huntley, can you unmute yourself and state your name?
Your Honor, for the sake of time, I would wait this person present.
All right, we'll waive his presence for the purposes of this hearing. Send this matter for exam.
Yes, Your Honor. I do have paper discovery with Matt. I do not know if there's any video discovery. Looks like it's
I'll put on the record that I have reached out to the OIC about digital and they have not gotten back to me, but I will email them again to get digital, if there is digital.
Just need to make sure, get a written order signed by the court, that's the only way I can act on.
Yes, Your Honor.
All right. Parties available on April 18th at 10:15.
Yes, Your Honor. I can go.
Anything else?
No, Judge.
Nothing further, Your Honor. Thank you.
All right. Move the hearing.
Party's ready on Leah Smith. Calling case number 23-55983, the people of the state of Michigan versus Leah Smith. Defendant is charged with count 1, assault with a dangerous weapon, felonious assault. Count 2, weapons, felony, firearms. This matter is scheduled for examination.
Good morning, Your Honor. Rima Group on behalf of the people.
Jimmy Lee Gray appearing on behalf of the defendant, and defendant is to my greatest standard.
Smith, can you state your name for the record, please?
Leah Smith, Your Honor.
Thank you. All right, ready to proceed?
People are ready, Your Honor.
Call your first witness.
People call Dietrich Brown.
Your name.
Excuse me. Dietrich. You can spell it. D-E-T-R-I-C. Oh, okay. Oh, did you? Dietrich. Okay, what's your first name? Last name is Brown. Oh, like the color. Thank you.
Ron, they still up this way, please? Oh, the other way? Ron, yep. You can raise your right hand. You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
Pull the door towards you. Have a seat. I'm going to be asked a series of questions. First by the prosecutor, then by the defense attorney, and I may or may not ask you questions. You have to answer all your questions out loud verbally using words. Just can't shake your head when you do it now. Or say, you have to say yes, no. Okay? Also, when you ask the question, I need you to answer that question and stop. So if it's a yes or no type question, just say yes or no. And if they need additional information, they're just going to ask you another question. All right? We all have a tendency when we're talking about something that may have been traumatic to us, we have a tendency to ramble. We'll say this happened, and this happened, and this happened. We'll go on. If you do that, I'm going to miss something. If I miss something, I might not make the right decision. Okay? I know nothing about this case. Only thing I know about this case is the defendant's name and what she's charged with. And I know your name. That's it. I get all my information from what happens in court, one question, one answer at a time. That way I can understand it. Okay? Say yes?
Yes.
All right. Thank you. Proceed.
Thank you, Your Honor. Ms. Brown, I'm going to ask you please repeat your full name for the record.
Dietrich Brown.
Ms. Brown, I'm going to turn your attention back to March 7 of 2023. Were you on 15027 Manor Street?
Yes.
Is that in Detroit, Wayne County?
Yes.
Okay, what's at that location?
I live there.
Okay, and I'm gonna turn your attention to March 7th, early in the morning, around 8 a.m. Did something happen on your street that brings us to court today?
Yes, my neighbor, poured her car in front of my car.
Okay, your neighbor, what's your neighbor's name?
Layla Smith.
Okay, do you see that person here today?
Yes.
Can you point to that individual and describe something they're wearing?
Yes, she's over right there with glasses on and braids in her hair. I can't actually see what she's wearing, but I think it's a green sweater.
Your Honor, may the record reflect that this witness is identifying the defendant, Ms. Smith? Thank you, Your Honor. So at around 8 a.m., you said that you saw Ms. Smith. Where was Ms. Smith?
She was parked in front of my car.
Okay, that she was parked in a vehicle?
Yes.
Okay, and how did you see Ms. Smith? How did you come about seeing her?
She pulled her car in front of my car and she was playing a lot of loud music early in the morning. And it was like belligerent music. And I walked out to go up to her car to say, excuse me, but before I could say, excuse
Okay, I'm gonna
me,
stop you right there. So when you walked up to her car, what side of the car did you walk up to?
the passenger side,
Okay, and where was she seated in that car?
the drivers,
Okay, and after you walked up to that side of the car, were any of the windows down?
yes,
Okay, what side of the windows were down?
the driver.
The driver's side window?
No, the passenger side window was down.
And when the passenger side window was down, did you make contact with Ms. Smith?
Yes.
What happened with that?
When I went to approach the car to ask her to say, excuse me, before I can get the rest of the words out, she pulled out a gun and was like, Dee, get the F away from my car.
Okay, where did you see where she pulled the gun out from?
Yes.
Where did she pull the gun out?
Her purse.
Okay, could you describe the gun?
It was a silver gun with a black handle.
Okay, and when you said that she pulled the gun out, do you remember what direction she was pointing that gun at?
Yes.
What direction was that?
Me.
Okay, and as she pointed that gun in your direction, did she say anything?
Yes.
What did she say?
Told me to get the F away from her car, and she has her CPL.
Okay, and how did that make you feel?
Scared.
Okay, after she did that, what did you do?
I went in the house and told her I was going to call the police.
Did you call the police?
Yes, I did.
Nothing further.
Well, Donna, I have a video of the incident that the complainant supplied to the police. And I would like to have that video shown. Just because it goes directly to the witness's testimony and her credibility.
Okay.
I can assist in that, yeah. Can I share screen?
Hold on 1 second. Okay, yeah, share screen.
I have flashes.
You know, because of the microphone, it's not very.
A video.
Okay.
I'll have questions about it later. But before you start, Ms. Brown.
Yes.
This is a video that you supplied to the police, is that correct?
Yes.
All right.
Right?
Yes. Your Honor, I didn't know that the court had a video system here, so I brought a large screen TV just in case you could not see this particular video, because it's very crucial that the video be seen, and appreciate it because it directly contradicts what Ms. Brown has said. The very first thing is that she says that she went out because loud music was played. There is no loud music played. So, do you want to see a larger presentation of this video, or because it goes directly to the credibility of Ms. Brown?
No, I can see the video clearly.
All right.
And it also had some audio. With the, yeah. You got any questions of the witness?
I do.
Okay, you go ahead.
All right. Ms. Brown.
Yes,
Now, you and Ms. Smith have known each other for approximately 3 years, is that correct?
yes, I know of her.
Now, approximately a year or two ago, did you have an occasion to talk to Ms. Smith about damage to your car?
Yes,
And you said that you wanted her to repair the damage to your car, is that correct?
yes, but that
And
was
she
2 years.
refused. I understand, but she refused to repair the damage to your car, is that correct?
Yes,
Now, that was approximately 2 years ago.
yes,
All right, now, since that time, there has been some contention between the two of you, is that correct?
yes,
You have filed police reports against her, and she has filed police reports against you, is that correct?
yes,
All right, now, on this particular day, you indicate that you heard loud music playing in her car, and you went out to the car to tell her to turn the music down, is that correct?
yes.
All right, now, this is this a Ring camera that's on your porch, or is it some other type of camera?
It's another type of camera.
I believe it's upper right-hand corner, says Nest. Is
Yes.
that it?
Mm-hmm. It sits right in my window. The doorbell camera did not catch that because the doorbell camera is not working. So I use my inside cameras and I focus them on the outside. So it would not pick up any audio at all. It just pick up just what you see.
Yeah. That is totally false. I have the video on my computer, and it does have audio. I'm going to play that for the court.
Right.
It's the same video, but it has
Okay.
audio. Your Honor, may I hand you my laptop and you can hear the audio on this?
Well, actually, anybody else here can just hold it up to the microphone.
That loud noise was Miss Brown coming out of the house and the door. Video apparatus caught that sound.
You can tell.
Unfortunately, it's not very loud, the audio portion, other than the coming out of the door. On my camera that I brought, or TV that I brought, you could hear the sound a lot better.
Can you play it one more time on this one? Because I could hear the sounds in the background. Can you turn it up just a little bit?
Oh,
Yeah.
oh, he took it off. It's not on. Share.
No, she's putting it back on.
Oh.
May I approach the witness, Your Honor?
Or
I wanted her to hear the sound that's coming.
no, I'm gonna play it again. I'm gonna play the whole thing again on the, it's only a few seconds. Play the whole thing again on again, I could hear some of the background noise when it played the first time, so we just turned it up. It sounded like a TV. Oh. Hold on.
Yeah.
Ms. Brown, you saw the video, is that correct?
Yes.
Did
Hold
you
on
hear?
a second. Can you turn that down? You have to turn that off, otherwise we'll get feedback.
You did see the video, is that correct, Ms. Brown?
Yes.
And that's the video you supplied to the police?
Yes.
And in your statement to the police, you indicated that the video does not probably, or may not show a gun being pointed at you, is that correct?
Yes. No, I didn't say that.
I'm going to show you because this is attached to the commission. Your Honor, I've supplied the court with a memorandum of law, and there's exhibit A attached to it. May I approach the witness, Your Honor?
Yeah.
Ms. Brown, I'm going to show you what has been marked Defendant's Exhibit A. And I just read to yourself the part that's started with the victim in the second paragraph.
Right here.
Yes, that's started right there, the victim.
Okay.
Just read it to yourself. Now, does that refresh your recollection as to whether or not you told the police that? All right, you did tell them that, is that correct? Was that yes or no?
Yes.
So when you submitted that police report to the police officer, I'm sorry, the video to the police officer, you knew that it did not show her pointing a gun at you, is that correct?
Yes.
All right. Now, you also indicated that she reached into a big brown purse that was in the passenger seat, is that correct?
Yes.
And then she pulled a gun from the passenger seat and pointed it at you, is that correct?
Yes.
Now, you indicated that she said something about she'll shoot you and so forth, is that correct?
Yes.
Now, you saw the video. At what point did you react as though you had been assaulted with a gun?
When I approached the car, I asked her, I said, "We pulling out guns now?" And she told me to get the F away from her car because she has her CPLs, and I stepped back.
So you're saying at the very beginning,
Yes.
she pulled the gun out.
Mm-hmm.
And you said, I'm trying to understand your reaction. You said you stepped back?
Yeah, she had a gun.
All right. Could you tell me, could you play the video again, please? you're approaching the car now, and could you tell me at what point you step back?
Right there.
Right where? You're leaving the vehicle,
Yes.
ma'am, but you said that she accosted you with the gun as soon as you got there, and you all had conversation after she pulled the gun on you. At the very end, you walk away, but there's several seconds of conversation before you walk away. And according to your testimony here today, she pulled that gun out as soon as you got to the vehicle. Is that correct?
Yes.
And then, so you step back when you walk away several seconds later.
Because I couldn't believe that she pulled the gun out. I couldn't believe it.
Oh, I see. So you didn't step back right away then after you saw it?
Not right away, but I left the car.
Now, you indicated that loud music was playing, and that's caused you to go outside. But you didn't hear any loud music on that video, did you?
Of course, you're not gonna hear it because it's not an outside camera, it's an indoor camera. You're gonna hear everything that's inside of my house, not outside.
So, the background noise, that's
The TV.
That's being heard, you're saying that was from the inside of the house?
Yes, everything you hear is inside my house.
I think Your Honor, I'd like to discuss this with the prosecutor. Your Honor, may I approach?
Sure. You want to vote?
I think it's a lot clearer. I'd like for the court to view this video and also like for the witness to.
You put it from there, no, it's good.
Okay.
Wait 1 second.
And you see yourself approaching the vehicle, is that correct?
Say yes.
Yes.
And you indicated as soon as you got alongside the vehicle, she pulled a gun on you, is that correct?
Yes, when I walked up to the vehicle. She's ready to go now.
and you're walking toward the gun, you're not walking back,
I can't believe that she pulled it out.
but you're walking toward something that you say is a gun. Is that correct?
Yes,
And then you walk away after allegedly you've been assaulted with a gun. Is that correct?
mm-hmm,
Yes.
yes, and I almost used to bathroom on myself too.
That you almost used the bathroom on yourself when she pulled that gun on you?
Well, yes,
Oh,
that's how scared I was.
I see. Now, you indicate you and the defendant have had exchange between the two of you where you called the police on one another. Is that correct?
Yes,
So you dislike her, don't you?
I wouldn't say that.
Oh, you like her?
The neighbor, I don't know her.
Oh, but you've had 3 years of conflict with her. Is that correct?
Off and on.
And you like her?
I wouldn't say I dislike her.
You like her?
I mean, she's a neighbor.
Would you answer my question, yes or no, please? Do you like her?
Yes.
Okay. All right. Now, the front window, you indicate that the front window of the vehicle was down. Is that correct?
Yes.
Now, you see the snow and so forth on the ground, right?
Yes.
And you saying that she was in her car with the windows down?
Yes. Playing loud music.
Now, you indicate that although you have been filing dueling police reports against each other, you like her.
I don't like her ways.
Which is it? You like her or you don't?
I don't like her ways.
I mean, you dislike her ways?
Yes.
Now, in your police report, you indicate that I'm tired of her calling the police on me. Is that correct?
Yes.
So you think filing this felonious assault complaint will make her stop filing police reports against you?
I'm not sure.
You have a reason to retaliate against Ms. Smith, don't you?
No, I don't.
Ms. Smith is due in court on Thursday of this week on a false police report. Is that a report that she made about you?
I'm not sure.
Or in your statement, you indicate that this is Exhibit B. The last time she called the police, they gave her a ticket. Is that correct?
Yes.
So you know about the ticket that she got?
Yes.
So why would you know about it if you were not the complainant in the ticket?
I wasn't the complainant. I was looking out the window when they gave her a ticket.
But how do you know they gave her a ticket?
It's on my block. She wouldn't take the ticket, so he put it in the mailbox.
Oh, so she was outside.
They knocked on her door, the police did. She came to the door, upset. The police got ready to hand her the ticket. She told them to put it in the mailbox, and they did so.
Oh, you heard her say, put it in the
I'm
mailbox.
standing in my door.
You
I
heard
didn't
her say,
hear
put it.
her, but
I need you to listen to the
Okay.
question and answer the question, please. Just answer the question.
So you heard her say, put it in the mailbox.
yes, I heard her say it.
Now, earlier you just said, I didn't hear her. Now, which is it?
I heard her.
So when you said you didn't hear her, you made a mistake?
Yes.
All right, I have no further questions.
No, Your Honor.
Thank you, step down. Further witnesses?
No further witnesses, Your Honor.
Defense has no witnesses.
Argument?
Judge, people move for bind over, and reserve argument.
Right. The testimony in this case establishes that the complainant and the defendant have had years of conflict going on between them, filing dual police reports. The complainant says that she heard loud music playing, and that caused her to go out to the defendant's vehicle and ask her to turn the music down. She indicates that I think it's the Nest video camera that she has, does not pick up sound, but the court could hear the door slamming, and the court could hear other noises. The question becomes, the witness had previously said that the equipment did not pick up sound. So the mere fact that she alleged that it did not pick up sound, and then she acknowledges that it picked up sound, shows her capacity to tell the truth. It seems to me that she will say whatever is convenient. Namely, I heard her tell the police put it in the mailbox, and then she said, well, I didn't hear her say it. And then she switched back to, I heard her say it. I think it's just a true issue from the very beginning. Starting when she first got to the vehicle, she claimed that the defendant pulled a gun on her and that she stepped back. But from the very beginning of that video, she didn't step back, she stepped forward. And then toward the end of the video, it was only 43 seconds, but toward the end of the video, she did walk away. And then at that point, she said that's when she stepped back, when she walked away at the end of the video. However, after being reminded that she allegedly, well, she said that she was assaulted as soon as she got to the vehicle with the window down, which I find hard to believe that the window would be down with snow all over the ground. It's just hard to believe. You certainly can't make out that the window is down on the video. It appears that the window is up. The video does not show the complainant, the defendant reaching into the front passenger seat. Admittedly, it's a video that is not 100% clear, but you could see a large body moving into the passenger seat to get a gun out of it, if in fact any movement was going on in that vehicle. The most telling part of Ms. Brown's testimony is the fact that she claimed that she almost wet herself when the defendant pulled a gun on her. Yet she lunges toward the vehicle right after she gets to the vehicle, which tend to indicate that she's not reacting to a weapon being pulled on her. A natural response to a weapon being pulled on you is to jump over the moon, especially if you're not expecting someone to pull a gun on you. And it's a very startling event, a very provocative event. And she is calm as a cucumber throughout that video. I think she acknowledges the history of strife between she and the defendant. And this is just a way to so-called get back at the defendant. She claimed at one point that she even likes the defendant. Then at another point, she cleaned it up and said, well, I dislike her ways. I don't know what the real issue is there, other than the fact that she does not want to admit that she has a motive for filing a false police report. It's just beyond belief that she would be assaulted with a weapon and then walk toward the vehicle as if nothing had happened, and then walk away from the vehicle as if nothing had happened. I think her testimony is not credible, and as part of the obligation of the magistrate at a preliminary examination is to weigh the competency of the evidence and the credibility of the witnesses. I think the witness has clearly been contradicted on a couple of points. And I think the calmness of the event does not belie the fact that she was assaulted with a gun. I ask that the court find that the charges that's contained in the complaint warrant have not been, there's no probable cause to believe that they've been established. And there's no probable cause to believe that the defendant assaulted Ms. Brown on March 7th in the city of Detroit.
Judge, the video doesn't necessarily contradict the testimony that the court heard here today, especially as to the testimony of what happened inside the vehicle, which we couldn't see, based on where the angle of the camera was. And I believe that's a question of fact for a trier factor.
All right, court having heard the testimony arguments finds as follows. Heard from witness Brown that on March 7th, 2023, approximately 8:00 a.m. Of 15027 Manor, which is her home, and her neighbor, the defendant, she identified sitting in the car in front of her car. Said there was loud music playing as she walked up to the car. Passenger window was down. She then stated that the defendant pulled out a gun and said, "You get the fuck away from my car." She has a CPL and pointed the gun at her. That was her initial testimony. And we showed the video. Which we could, from the video, we could hear appears to be the TV on in the house. You clearly hear the door opening and closing. There was no loud music playing. That's just clear to this court. And find out that this is a ongoing dispute between the two parties. And that they have a very contentious relationship, obviously. And Brown doesn't even really want to admit to that. She states that she doesn't, first she says she wouldn't just say she dislikes her, and then she says she likes her, and then she says she dislikes her ways. Admits that there was another incident where the defendant is being charged with filing a false police report. No. I guess in initially looking at her testimony, probable cause. However, in reviewing all of the testimony, what she would admit to and what she wouldn't admit to. Or I can't trust her. I can't take what she says as even to the level of probable cause at this point. And because of that, the court, not only questions her credibility, but I'm come to the determination that she's incredible. And that this is just, to the court, appears to be another dispute they could add to the ongoing disputes they've been having. And I'm not going to waste the court's time with it. But at this point, this matter is dismissed.
Thank you, Your Honor.
Thank you, Your Honor.
Let me use dismissal form, please. Yes, sir.
Madam Clerk, this is Attorney Salen. I was wondering if,
Hold on, Mr. Salem. Let me turn it up. I turned it down so I couldn't really hear you.
understood. Thank you.
All right, go ahead.
Thank you very much. Did you receive an update?
All right, let's try this one more time. All right, go
Okay.
ahead. There you go.
I'm Sante Gardner. It's an ongoing competency review. Have you received a report? It was a Judge Archer file for several hearings.
I don't see a recent one. There's a letter from January 13th. I don't know if there was a court date. Was the court date on behalf of that one?
Yes, it's supposed to be this afternoon. I have not received any updated referral indicating, report indicating that she is now competent.
All right. Sir, wait for your paperwork outside. We'll bring it out. Thank you.
Oh, so you. All right. Judge, do you want to look at this comp hearing? I don't really see a report in here. Or you want me to just call it? Yeah. It was,
On the report?
no,
Right, yeah, we can call it.
About 30 days. You want to talk?
you need a 30-day date. All right. Calling case number 2255323, the people of the state of Michigan versus Sante Gardner. Defendant is charged with count 1, stolen property, receiving and concealing $20,000 or more. Count 2, motor vehicle and lawful driving away. This matter is scheduled for a competency review.
Swearing on behalf of the people, good morning, Judge, P1P 86590.
And good morning, Your Honor. Alvin Salen, P23797, on behalf of Ms. Gardner. Judge, this is quite an old case. We've had a number of hearings. I think we may be at the point in time that the matter should be dismissed. She's been previously adjudicated to be incompetent. We've stipulated to that report, and I can just tell the court that I believe if you confer with Judge Archer and if the prosecutor's notes in this matter, I don't believe she's never achieved her competency in this matter, Judge.
He was found incompetent on January 10th, 2023. So the time limit has not passed. You know, well, and where is she locked up?
You've been at various shelters, Judge, through the court.
I have to have her body. I can't make any determination without her here. She's supposed to be here today. You're gonna need to get in contact with, what I'm gonna do is I'm gonna put this over. Has she been in any kind of treatment, do you know?
She's been with a shelter with Team Wellness, Your Honor. I'll try to get an update on that, Judge. If you can give me some time, I may have to contact a worker over there. I know there's been 4 referrals, Judge, 4 or 5 referrals.
Has she gone to any of them?
Yes, they finally did do a report, Judge, and you're right. Based on that report, she was held to be incompetent in January.
Okay, then we're nowhere near the time limit of, but she should be in treatment, not just a homeless shelter. She's supposed to be in somewhere getting treatment.
Give me enough time, Judge. I'll try to assist the court in getting her present location, Judge.
All right, I'm gonna put this over to May 10th at 8:30.
Thank you, Judge.
She has to be here. I'm gonna issue a habeas.
Judge, if she's in an inpatient proceeding, can she appear by Zoom?
Yes.
Thank you, sir. Have a good day, Your Honor.
Okay, you too.
Thank you, Judge.
Ms. Cross, what do you have?
Good morning, Judge. I was spot appointed on David West.
Oh, his attorney showed up.
Oh, his attorney showed up?
Yes.
Okay, so I don't have to worry about it.
Okay, thank you.
Thank you.
Right, we ready on, Namir Zena,
Yes, great.
calling case. Are you on that one?
Yes.
Calling case number 20-55622, the people of the state of Michigan versus Namir Zena. Defendant number 1 is charged with count 1, controlled substance, count 2, strike count 2. This matter is scheduled for examination.
Morning, Judge Altorno, we have the people, P number P86590.
Hey, good morning, Judge. May it please the small summary court, I'm here Mac, representing Mr. Namir Zaya, P76306.
Counsel, take it you never received any discovery in this matter?
That is correct, Judge.
And the court order signed March 29th, 2023. Prosecutor wishes to make any statement.
The people are unable to locate discovery and they're unable to proceed at this time.
That is the court to dismiss without prejudice.
All right, matter is dismissed without prejudice.
Thank you.
Thank you.
Thank you.
I like the last one, she's talking to her clients. Oh, I'm sorry, Rima. I'm sorry.
For what?
About, you're gonna ask.
Oh,
me
no,
about-
it's okay.
He said, email it or something.
Okay, great.
If not, you can,
Okay.
I don't know.
I'm sure you want to talk about it afterwards. You're gonna laugh about it.
All right, last one.
Now you're ready.
You ready? Oh, I need to find.
Okay, hold on. This is not a thing.
Right, I don't know. I think, wasn't that the prosecutor's motion?
It might have been, right? But we can have-
They didn't. Rima, I'm, Ramon Thomas,
Yes.
why was that dismissed?
No, it's insurance.
Well, it wasn't on the original, so that's why I told him to bring it back up. Yeah, they called. I'm like, I don't know.
Okay.
All right. All right, we ready, Cheney?
Yes, CR
Oh, you know what, Cheney meeting, so too. I think it's in count. Calling case number 2356053, the people of the state of Michigan versus Ulysses Shamey, defendant number 1 is charged with count 1, assault with intent to murder. Count 2, assault with intent to murder. Count 3, assault with intent to do great bodily harm, less than murder or by strangulation. Count 4, assault with intent to do great bodily harm, less than murder or by strangulation. Count 5, assault with a dangerous weapon, felonious assault. Count 6, assault with a dangerous weapon, felonious assault. Count 7, count 8, count 9, count 10, count 11, count 12. Weapons, felony, firearm. Count 13, police officer assaulting, resisting, obstructing. This matter is scheduled for examination.
Good morning, Your Honor. Remax on behalf of the people. And good morning, Your Honor. May it please the court, Camilla Barkovic, P78254, appearing on behalf of Mr. Cheney, who is physically present.
Judge, at this time, the people are unable to proceed on counts 1 through 12 as no necessary civilian witnesses showed up. And I believe there's an understanding that on count 13, defense counsel and her client will be waiting.
Your Honor, that is an accurate statement. Counts 1 through 12 would be dismissed upon the court's approval. I have advised my client of his right to have a preliminary examination on count 13, which is assault, resisting, and/or obstructing a police officer. We thoroughly discussed the anticipated proofs and his options in this matter, and it's my understanding that he has voluntarily decided to waive his exam on count 13.
All right, Mr. Cheney, can you state your name for the record, please?
Ulysses Lee Cheney.
Mr. Cheney, you understand you have a statutory right in your exam where the statement shows by probable cause of crimes and probable cause that you had something to do with committing that crime. And in this case, we're only talking about count 13 of these charges, which is assaulting, resisting, obstructing a police officer. You understand that?
Yeah.
Anybody promise you anything or threaten you in any way that you waive your right to commit exam?
No.
You waive your right freely and voluntarily after having an opportunity to talk to your attorney about it.
Yes.
And you signed the waiver of examination form?
Yes, I did.
All right, people have any objections?
No objection, Your Honor.
All right, court will find that you freely and voluntarily waive your right to preliminary exam as bound over the Wayne County Circuit Court of Criminal Division for arraignment on information. That's the only case he has? Also?
Here, Judge, yes, and before you in this court. He does have another matter pending in front of Judge King.
All right. Arraignment on information is going to be April 17th, 2023, 9 o'clock.
Thank you. And Judge, are counts 1 through 12 dismissed?
Yes.
Thank you. There is one final issue, and that is a request for a bond modification.
You wish to be heard on it?
I'll leave it to the discretion of the court, Your Honor.
And Judge, I would be happy to present an argument as to why I believe bond should be reduced.
All right, well, you had a $250,000 cash bond, and I assume it's because he was charged with a capital offense. Now, all of that is gone. The only thing left is the existing obstructing police officer. For 2 years. Go ahead.
That's correct, Judge. All of the high security felonies and felony firearm counts have been dismissed. The only thing that remains at the present time is a 2-year low severity felony. Bond in this matter is currently set at $250,000 cash surety only. If the defendant were able to make bond, he would be required to be equipped with an electronic monitoring device. I have no objection with the tether requirement remaining, but I am asking for a reduction in the monetary amount of bond. I'd ask for something under $25,000. In fact, I'm asking for a personal bond. My client does not have any significant or substantial criminal history. He is 35 years old. He's a lifelong Michigan resident. He has extremely strong family support. In fact, Judge, when I was retained, 10 to 11 of his family members came to meet with me at my office. I think that demonstrates the support he would have if he were to be released in the community. He has a history of employment, and his immediate family would gladly allow him to reside with them if he were to be released. I think $250,000 is excessive under the circumstances.
Judge, I would object to a reduction in the bond. It brought to my attention that Mr. Cheney has a pending case that involves charges of torture and unlawful imprisonment in Judge King's courtroom. I understand the court's decision if they decide to reduce the bond, but given the seriousness and the nature of the charges pending across the hallway, people would object to reduction.
And Judge, just in response to that, obviously, the court is to consider the facts and circumstances of the case in front of it. I understand that the court, under the court rule, can consider other matters, including defendant's prior history. But my client is presumed innocent. He would still have a very hefty bond on that case. In fact, I do believe it is of an equivalent amount. Accordingly, that is being addressed in the other matter. I think for the reasons I've already stated on the record, my request for a significant reduction is warranted.
Well, I mean, I understand he has another case and he has some serious charges on the other case, but he has a bond on that case. You know, I don't have anything to do with it. I can only deal with actually what's before me. And although I can take that in consideration and do, right now, this case before me is a 2-year. And without any substantial criminal history, you know, that 2 years is automatically probationable. So, you know, he'll, as long as he has the other bond on the other case, and they'll deal with that one there. So on this one, the court's going to reduce the bond to a 10,000 personal with the GPS tether.
Thank you, Judge.
Thank you.
I'll see you in a little bit.
Oh. Yeah, let's do that. No, that's it, right there.
We done.
I thought we'll have it to